is back in session.
All right, you call the next case?
State of Tennessee versus Michael Robert Quinn.
Good morning. May it please the court, my name is Joseph Sadigian. I represent Michael Robert Quinn, and I would like to reserve 4 minutes for rebuttal.
All right, Mr. Seeley.
I would like to begin with the first argument that trial court error caused Mr. Quinn to be denied his right to a preliminary hearing in General Sessions Court, and then proceed with the arguments that relate to the motion to suppress, and then turn to the last 5 arguments. Mr. Quinn had a right to a preliminary hearing. This issue was raised for the first time in the motion for a new trial. And as the state points out, Mr. Quinn did not raise this issue within 30 days of his arraignment on the presentment pursuant to Tennessee Rules of Criminal Procedure 5E4. And the record fails to demonstrate exactly why Mr. Quinn missed this preliminary hearing or demonstrate any bad faith by the state. Mr. Quinn would simply argue, though, that the record does demonstrate a complete denial of counsel at a critical stage of the proceedings in his prosecution, and that is the time from the moment that Mr. Hedricks filed his motion to withdraw and the time that Mr. Bell was appointed. Mr. Quinn really had no counsel during that time, and that was the time where the preliminary hearing, time to request a preliminary hearing within 30 days lapsed. And I would simply argue to the court that this is structural error, and even if the court finds it's not preserved in the assignment of error or in the motion for a new trial or any of these other proceedings, that it would simply be something the court can consider under Rule 36B of the Rules of Appellate Procedure.
What if it is not structural error? And so let's say that it is either subject to regular harmless error analysis or non-structural constitutional harmless error analysis. If it's not structural error, what's the remedy? So during this time when before his issues were winding up in Sessions Court and he had to be taken away apparently, the case was presented then to the grand jury, which returned a presentment charging him with the offenses. Then we have a jury's verdict finding guilt beyond a reasonable doubt. If this isn't a structural error, would you have the court vacate the jury's verdict, finding guilt beyond a reasonable doubt, to remand for a hearing to determine whether the offenses are supported by probable cause?
I think that would essentially be a harmless error analysis.
So if it's not structural, it's nothing really?
Well, right. You would have to go back and do a harmless error analysis if you found that he had some remedy. And then
the jury trial would cure anything, right?
Because the jury did more than find probable cause, right, and that would be true. So
is it true in this scenario then? I'm just trying to figure out where the argument is.
Right.
Is it true in this scenario that if it's not structural error, there is no remedy? It's completely harmless error?
That's correct.
Okay.
Yeah.
All right, that's fair enough.
So you would have to find it to be structural error, and that's why I'm saying that federal case law does support the preliminary hearing being a critical stage of the proceeding, and denial of counsel at that stage would then be structural error, and that's the argument.
Okay, that's fair enough. Thank you.
Then turning to the suppression issues, again, these sort of wrap themselves around because this arrest was done very carefully. The investigator Jinks obtained a warrant to stop the car. The video demonstrates that the canine was there within 5 or 6 minutes. And during that time, of course, they were taking him out of the car, so I can't really see where there was any undue delay. The courts have held that a dog sniff does not a search. So the dog alerted to the car. And those issues, I'll just submit them on the brief. The cell phone, again, this is another troubling issue. I think it's clear that Investigator Jinks did a search of the phone prior to getting the search warrant. When he had the phone in his hand, he scrolled through it. Both the revocation hearing testimony and the testimony at the motion to suppress demonstrate that. So, but then again, you get to the affidavit for the search warrant, and there's no mention of that. So my argument would simply be that the affidavit is just a bare bones affidavit that doesn't support probable cause without the, but again, you know, I think the case law is against me. I've read over the affidavit several times, and I've seen affidavits with less than that one that, you know, have been upheld. But nevertheless, then I would turn to Riley and say that you really should have more protection with your cell phone. But of course, the State versus Ham, you know, finds that by signing Rule 7 of the probation order, Mr. Quinn was entitled to, had no more rights than a parolee. Again, you know, Rule 7, by signing that probation order, it does seem that there is a strong argument that he waived the right to have his phone searched without a cell phone, without a warrant. So
was any part of the warrant, was any of the information contained in the warrant, the affidavit supporting the warrant, was any of that information obtained from the officer's initial perusal of the cell phone?
No, it does not. It was simply the same language that officers often use, that I am been working as an officer investigating drug crimes for a number of years, and that I have found that people who sell drugs use their cell phones to set up buys and so forth, and I believe based on the amount of the drugs and so forth that I would find evidence on his phone that would support the intent to distribute element, which is, you know, also supported by the packaging and the amount and the scales that were found. So there was nothing in the affidavit that's any different than any other affidavit you would find. So that's really all I would want to say on the issues presented 2, 3, and 4, which all, again, wrap around the suppression issue. Number 5 is somewhat of a novel issue, the failure to make a return on the arrest warrant. Now, I couldn't find any cases on return of a search warrant, of an arrest warrant. There is, of course, United States versus Hilliard, which held that the return on a search warrant is a ministerial function and does not affect the validity of the warrant or its execution. But Mr. Quinn contends that the failure to make a return on an arrest warrant violates the plain language of Tennessee Rules of Criminal Procedure 4E4A and invalidates the arrest warrant. Now, again, the only argument I have in support of that is the plain language, the mandatory use of the word shall, and I've briefed that, and the remedy that I've proposed is in the brief on that issue. So then we turn to issue 6, which is the denial of Mr. Quinn's pro se request for a continuance.
Counsel, can I go back to your issue quickly? What would be the remedy? Let's say that the court agreed with you that the arrest warrant should have been returned. Its failure to do so was improper under the rules of procedure. What's the remedy?
I would say that the remedy would be to remand the case back to the trial court to find that without an arrest warrant, the stop was not supported by probable cause, and then to find that, therefore, the stop and everything that came from it should be suppressed.
The arrest occurred after the stop and after the search, correct?
That's correct, but the stop was based on the fact that they had a warrant for his arrest and knew that it was Mr. Quinn driving the car. So there was no traffic violation, there was no evidence of any expired tags or anything of that nature. So the arrest was solely based on the fact that they had a warrant. The stop was solely based on the fact that they had a warrant for his arrest. That would be the argument there. Now, on the issue of Mr. Quinn's pro se request for a continuance, again, I would submit this in brief with the argument that the trial court made no inquiry of Mr. Bell concerning the preparation he had made for trial nor did the trial court ask Mr. Quinn questions that I think should be asked before any trial begins. The trial court should have asked Mr. Quinn if he had enough time to talk with his attorney, if he had gone over the charges, if his attorney had reviewed the charges with him, if the attorney had told him what the state had to prove to find him guilty, if the attorney had discussed with Mr. Quinn any defenses that he may have, if the attorney had discussed with Mr. Quinn any witnesses that he wanted called, and if Mr. Quinn was satisfied with the services of his attorney. I think that type of colloquy should have been done with Mr. Quinn, considering his expression that we're not ready for trial. And that wasn't done. And in fact, all the court did was turn to Mr. Bell and say, "Are you ready for trial?" And he said, "Yes, I am." And that was it. And the court went on to essentially tell Mr. Quinn, "Look, maybe you only met with Mr. Bell 3 times and then, 5 minutes before trial, but I can tell you he's been working on your case when you haven't been around, and, he's been doing things that you haven't seen, and so he's done a lot of work in your case." And I don't think that's really the way to have resolved this issue. And then, again, on brief, I point out, and I've gone through all the facts in the brief. I presented them all. I know the court hasn't looked at the transcript, but I stated the facts, and I don't think that I think I've stated them fairly plainly. But then what happens at trial is a very critical piece of evidence, this police report that the court had ruled that Mr. Quinn's statements were not coming in. And the state was meticulous about editing the video and everything to keep any of Mr. Quinn's statements out. But then on rebuttal, Mr. Bell presents Investigator Jinks with this arrest report and has him read this part that says the drugs were found in a Jordan box in the back of the truck. That's it. Now, instead of just leaving it there, he then introduces the entire arrest report, and in it is the statement of Mr. Quinn that was going to be kept out, which was admitting ownership of that Jordan box. And again, I don't think that this was harmless error, because it became the linchpin of the state's closing argument. They said, if you consider nothing else, look at Exhibit 18, which was the statement in the arrest report. Said that alone proves the case. Because the jury did have questions. I mean, the questions were simply like if he wasn't going to sell the drugs at the school, if he was simply there with the drugs in his car, is that enough? And the court, of course, read him the statute. But so I think this was a critical issue, and I think it reflects on the lack of preparedness of Mr. Bell and the lack of time that he and Mr. Quinn had to talk. And I think had this pro se request for a continuance been honored, the result of the trial would have been different. And I would, again, argue to the court that this is essentially a constructive denial of counsel, that you're being given counsel that is not prepared.
Sounds like an issue that's more commonly raised, obviously, in post-conviction relief, where they're coming in and saying counsel didn't prepare, counsel didn't move for a continuance, counsel didn't meet with me. Why would that not be more appropriate to address this issue, especially considering the granting of continuance is at the discretion of the trial court?
That's true. And then the only thing I can say in reply to that is that, again, this would be, I would argue it's essentially become structural error at some point, and something that can be argued or dealt with on a direct appeal. But that's all I really have said.
Are you asking us to address that issue now in this forum?
Yes, if you find that it's preserved or can be reached under Rule 36B, yes. It's.
But you're not asking us to address whether trial counsel was ineffective on that issue?
No. In fact,
that takes away from your argument, though, right? Because you said that it would have affected the outcome of the trial, so we necessarily have to rule on that if you want us to rule.
Well,
a denial of a continuance, you would have to, on a claim of an improper denial of continuance, wouldn't you have to show prejudice?
The case that I've cited for that is a direct appeal case, because I'm trying to be very careful not to move into those post-conviction remedies, because if you, you lose your right to habeas if you, raise these issues.
Not to put words in his mouth, but I think that's what Judge Holloway is asking you, and that's what I'm asking you too. It sounds like your claim of prejudice on the wrongful denial of a continuance is that as you said, he effectively was without counsel, without effective counsel.
Well, let's just say he was it was a denial of counsel and not ineffective counsel. That's why I'm couching it in those terms and not as ineffective counsel. And because it, the Flynn case, the one I cite, where it was a claim of constructive denial of counsel at critical stage of the proceeding presented on direct appeal, and it quotes Chronic, the United States Supreme Court case. So it's not ineffective counsel, it's constructive denial of counsel. So if the court does address it, I would ask that it only be addressed on those grounds on direct appeal and not as a Strickland claim, but as a Chronic claim.
But a Chronic claim is a post-conviction claim. It's a denial of the Sixth Amendment right to counsel, just as a Strickland claim is, though.
Well, but I don't think it precludes you from then arguing on habeas Strickland as ineffective counsel. And that would simply be my argument. But whatever, I don't want it to be done as a Strickland claim or as a habeas type claim, because you don't want to raise those claims on direct appeal.
Mr. Addition, I understand to get down to your rebuttal, but I had one more question. If I could go back to the arrest warrant issue. And I was trying to think of this when you were saying it. Is it analogous? Okay, let's say the arrest warrant was not good because it wasn't returned. But we have an officer serving that warrant who thinks it's good. Is that not analogous to a situation where, let's say, an officer stops a vehicle for a perceived violation? And after the officer stops the vehicle, let's say it's a tag light that a vehicle doesn't require a tag light. He finds the passenger with drugs in the car and obvious smell, plain sight, and all that type of stuff. In that situation, you can still prosecute on the crimes you discovered, even though the stop was turned out to not be a violation of the law. And it seems like to me, if this officer thought this arrest warrant was valid, then the crimes he discovered as a result of serving it would be valid. Why is that not the case?
Well, I mean, I think there is case law that supports that idea. I would simply argue that without a valid arrest warrant, being that that was the whole basis for the stop, that it was an illegal stop, and that and it's done because of the failure to make the return. Now, perhaps there's no clear remedy for failure to make a return on arrest warrant. Let's say the language is mandatory and not permissive, and by the use of the word shall, then with no clear remedy in the statute, I would say that the court could find that it's a violation of the Fourth Amendment and find the stop was invalid based on that alone. And I know my time's up.
All right.
Yeah, it is up.
We'll give you a little bit of rebuttal time if you want to at the end.
Thank you.
All right, Mr. Groves.
May it please the court, Alan Groves again on behalf of the state. Michael Quinn was on probation when he drove his truck containing 20 grams of methamphetamine onto an elementary school property. This court should affirm his convictions and 25-year sentence. Defense counsel was able to briefly hit on all 8 of these issues, so I'm going to run through them in similar fashion. First, beginning with the lack of a preliminary hearing. I take it that counsel is essentially conceding that this claim is time-barred under Rule 5 because it wasn't raised within 30 days of the arraignment on the presentment. And furthermore, it's really not clear whether the defendant actually waived his right to a preliminary hearing by failing to appear. From the record, Mr. Hendrick, when he represented defendant and moved to withdraw his counsel, said that it was not his fault that he missed the preliminary hearing, and that on one of the days that it was scheduled to happen, the defendant was removed due to some unspecified difficulty. That's really all that we have in the record as to why he did not appear. But it's very possible that he waived his right to a preliminary hearing by failing to appear for reasons not outside his control.
So, General Groves, maybe even more fundamentally, your friend on the other side, I think, conceded that if we do not find that the denial of the right to a preliminary hearing is a structural constitutional error, whatever error there is, if there is one, is harmless. Does his client have a constitutional right to a preliminary hearing?
There is no remedy under Rule 5 for failing to make a timely objection. It doesn't provide for a remedy, so it's just time barred. And there's no harmless error analysis or plain error review for this type of claim. I couldn't find any examples.
Even more fundamentally, though, does a criminal defendant have a constitutional right to a preliminary hearing?
I don't think the defendant has identified a constitutional basis for that, but I haven't briefed the issue, so I wouldn't want to.
Fair enough. Could the time be extended under the rules of criminal procedure?
This court has interpreted Rule 5 to contain implicitly a bad faith exception, and the court has said that if the state acts in bad faith, that it operates to toll, essentially, the 30-day requirement to raise the issue. But that's the only circumstances under which the timeline could be extended.
So, and you'll help me with the precise rule, and I'm embarrassed to admit that it escapes me. Maybe Rule 45, which governs timelines in criminal court. And some of those timelines cannot be extended. So, for example, the classic one is a failure to file a motion for a new trial. You can't extend that time. But Rule 5 is not included among the list of the 3 or 4 rules whose time can't be extended. Does that indicate that the timeline under Rule 5 could be extended by the court in the exercise of its discretion if it chose to do so?
I don't think so. As far as I know, the court has only said that when the state operates in bad faith, that's the only circumstance. I'm not aware of any other authority.
Just purely an interpretation of the rules of criminal procedure, I think is what I was asking.
Yeah, I couldn't speak to that, Your Honor. I'd have to go back and look at the Rule 45 that you're referencing, but to my knowledge, I don't think it addresses this specific circumstance.
In any event, though, there was no other request ever made for a preliminary hearing until the motion for new trial.
Not until the motion for new trial. Yeah. Yes, Your Honor. With respect to the vehicle search and the reliability of the canine alert, this issue has been waived because the defendant didn't even challenge the validity of the vehicle search in his motion to suppress or at the suppression hearing. The trial court just kind of sua sponte addressed this issue in its suppression order. So we're asserting that issue has been waived because the defendant did not timely raise the issue. But regardless of whether the court analyzed that under plenary or plain error review, there was no error because the canine officer testified to his experience as a certified canine officer. He testified to the dog's experience and training and its reliability at 95% accuracy. And as we discussed in the brief, this dog apparently was even more trained and experienced and reliable than the dog in England, where the Tennessee Supreme Court addressed a similar issue. And there's some suggestion in the briefing that the officer's opinion about the dog alerting was just subjective. That's not borne out by the transcript. Your Honors will see that the officer testified that this particular dog would have a noticeable change in behavior, like a head kick when it alerted, and then it would go into a final response, which is exactly what he observed at the scene. The dog had a head kick and then laid down completely, which was a little unusual because sometimes it would just sit down to indicate the final response, but he kind of explained that just kind of depends on the dog's positioning with respect to where the vehicle is. The cell phone search, again, I take it that counsel essentially concedes that under Ham, there was reason to search the cell phone because it was a condition of his probation. And he's just asserting the position of the dissent in that case, but this court's obviously bound by the majority opinion. And as a condition of probation, the officers were justified in conducting that cell phone search. So the court doesn't really need to reach this issue of whether the search warrant that they eventually got was provided an independent source, and going into the details of what was in the affidavit, what wasn't. But I agree with counsel that nothing from that initial look through the phone was used in the affidavit for the search warrant.
So General, on that point, Ham goes a little further than just opening up all searches to people on probation, it requires an analysis of the language of the waiver in the original probation order. And I think in Ham, the Supreme Court was looking at the standard TDOC language, and from that concluded that the probationer had waived his right to searches upon probable cause. Is the language of the waiver in the record in this case?
I believe it's cited in my brief.
Okay.
Yes.
Is it in the record, though?
Yeah, it would have been in the record.
Of course.
If I said
Okay, that's fine.
But it does reference that the defendant is consenting to searches of his property. So the cell phone would have
All right.
fallen
Is
within
it the
that.
standard TDOC language that we see, or is it different?
I don't want to speak to that, Your Honor, because I didn't go back and look at the standard language, but it didn't look unusual to me when I read it.
Okay. And Ham also requires that the officer know at the time of the search that the probationer is on probation. That doesn't appear to be an issue here.
It's not at issue. The defendant, during the search, just admitted to police officers that he was on probation for arson.
Did the officers know about that prior to the stop?
I don't believe so.
Okay. All right. Thank you.
At least I don't think the arresting officer knew that. Now, when the school had reported him and they were looking into him, they saw that he had an extensive criminal history. At some point or another, someone might have learned that he was on probation. I don't think the arresting officer did until it was admitted to him at the scene.
And the searching officer, though, the one that actually conducted the initial perusal of the cell phone, did he know ahead of his search that the defendant was on probation?
I believe so. I think it was the same officer.
All right. That's borne out in the record.
I'll stand on the record. I don't want to say for sure, but I believe it was the same officer. The next issue is the incomplete arrest warrant return. And again, I want to emphasize this issue is also waived, and that's conceded by the defendant in his brief. It was first raised in the motion for new trial. And Your Honors, I don't see how you could possibly get to plain error relief on an issue like this when the defendant concedes that there's no case law on this issue in Tennessee, apparently. So there can't be the breach of a clear and unequivocal rule of law, especially when all the case law we do have on the validity of the failure to make a return on a search warrant holds that it's merely a ministerial function. And Judge Holloway, to some of your questioning on this, I don't see how failing to make a return on the arrest warrant could invalidate the initial detention, because it's all about what the officer believed and whether he had probable cause to make that initial detention. So if the arrest warrant itself was valid, there was probable cause, and whether the return was filled out later just couldn't affect that analysis at all. On the pro se motion for a continuance, the trial court didn't abuse its discretion here because the defendant wasn't entitled to make a pro se motion for a continuance when he's represented by counsel. So the court's case law is pretty clear on this, that any pro se motions or filings by a litigant are essentially just a nullity when they're represented by counsel. They have to speak to the court through counsel. So the court wasn't even obliged to consider this pro se motion for continuance. And in any event, there's no prejudice because the record does clearly reflect that counsel was zealous in his advocacy. There was overwhelming proof of guilt. And the only thing the defendant really tries to hone in on here is the admission of the arrest report. And I think even if the court were to go down this rabbit trail, it would find that the defense counsel was kind of making a strategic decision about using this report because he believed it had at least some minimal impeachment value, since investigator Jinks had said that some of the drugs were found in the back seat rather than behind the front seat. Counsel was thinking there was a little bit of a discrepancy there in terms of where the drugs were found, so he wanted to introduce the arrest warrant, or the arrest report rather, for that impeachment purpose. So there was at least a tactical decision here, even if the court were to pursue that argument. I don't think counsel addressed the 404B issue with respect to the text messages, but as I take his argument, he basically concedes that the admission of these text messages were probative of his intent to sell or deliver, and he doesn't dispute that they're clear and convincing evidence of prior bad acts. He's only arguing that the unfair prejudice outweighed their probative value, since he says there's nothing to connect the text messages to the defendant's actions on that specific day. But that's simply not true. As the trial court properly found, several of these text messages were sent the day before the arrest, which is very strong evidence that the drugs that he had in the truck at the time of the arrest he did have intent to sell or deliver around that time period. So there's no error in the admission of the text messages discovered on the phone. And I don't believe the defendant did raise or address sufficiency or sentencing. So unless the court has further questions about those issues, I can rest on my brief for those.
All right.
Otherwise, we ask this court to affirm the judgment of the trial court.
Thank you, counsel. All right. Mr. Dijian, rebuttal.
But just to answer Judge Greenholt's questions, the record does, Mr. Skeen, the probation officer, does read the section of the probation order verbatim that says, "I agree to search without warrant of my person, vehicle, property, or place of residence by a probation, parole officer, or law enforcement officer at any time." And I believe the other papers were there. It's true I did not get to the sufficiency issue. I'd submit that in brief. As to sentencing, again, Judge Sword, obviously, I don't know that State v. Ham had come out at the time, but the existing statute wasn't a model of clarity, and so he did sentence him under the amended Drug-Free School Zone Act. But in reading Ham, it does appear that Mr. Quinn would still have the option of applying to the court that sentenced him for resentencing when the appeal is no longer pending. So I think that's really would resolve the sentencing issue. So unless there are any other questions from the court, I would just ask the court to reverse Mr. Quinn's conviction and remand it to the trial court. And thank you.
All right. Thank you, counsel.
Thank you. Thank you, Mr. President.
Y'all ready to go? Good. Did you call the next case?